Good morning and welcome to the District of Columbia Court of Appeals. We have two cases on our calendar this morning. We're going to hear the first and then take a brief pause, reconstitute the panel, and then resume. Our first case is 24 CO 362, Tony A. McClam versus the United States. Counsel.
Good morning, may it please the court. My name is Daniel Gonen. I'm here on behalf of the appellant Tony McClam. I'd like to reserve 2 minutes for rebuttal. There were two separate shootings in this case. They were separated by a fork in the road and a fresh impulse, giving rise to separate charges of assault with intent to kill. That much is now undisputed. What's true for the AWICs must be true for the homicide charges as well. There were two separate shootings giving rise to two sets of homicide charges. And that resolution of that issue is enough to establish both jurisdiction and the need for a reversal, because the government has abandoned its argument below that its election was not voluntary, and it concedes that a voluntary abandonment of a charge after jeopardy is attached is equivalent to an acquittal. And it also has abandoned the argument in its motion to dismiss that you have to seek dismissal of a specific count of the indictment to establish jurisdiction for an avenue appeal. Even if the court doesn't want to decide the question of factual separateness, there's another route to reversal, because the government has conceded that these two homicide charges are legally separate. And under Scarborough, legally separate or factually separate amount to the same thing. Conceptually distinct offenses. We have a conceptually distinct homicide offense that has had resulted in an implicit acquittal, and therefore double jeopardy bars a retrial of that concededly separate charge, whether factually separate or legally separate.
Can I, on that last point?
Sure.
Your assumption seems to be that offenses, well, incidents that are legally separate or factually separate for purposes of special unanimity, therefore logically must be separate criminal offenses for purposes of at least some double jeopardy principles. What makes you say that?
Williams, Haygood, and Washington, and other cases, but those are all cases that where this court has said, for Sixth Amendment unanimity purposes, you only get a special unanimity instruction if there are two separate criminal offenses contained within a single count of the indictment. If it's just different means of committing a single offense or different legal theories of liability, you do not get a special unanimity instruction. So as a matter of logic, if you are entitled to a special unanimity instruction under the Sixth Amendment, there have to be two conceptually distinct criminal offenses, not just conceptually distinct means of committing a single criminal offense. So
The United States argues otherwise and cites, among other things, cases like Brown, where this court has indicated that a special unanimity instruction was required. What's your response to that line of thinking or that line of authority?
Brown's a little bit muddled, right? Because it notes that there were two cases before Scarborough was decided. So before the concept of a legally distinct offense exists, in Hack and Davis, this court said the jury has to be unanimous on which of two distinct quantities of drugs a person possessed. Then Briscoe comes along, where the defendant was charged in 2 counts and was convicted of both counts. Nobody complained about that being improper, but the court said for punishment purposes, we think these offenses, these possession offenses merge, because, and there's a certain logic to that when it comes to possession, because you could divide a quantity of drugs and, you know, essentially down to the atomic level and call each one a separate act of possession, but there's no evidence that the legislature intended there to be double punishments for that sort of thing. So the offenses merge, and that's similar to the analysis that the court uses for possession of a firearm during a crime of violence. There, you can have, in this case, for example, you could have distinct PFCV offenses. The jury has to be unanimous on them, but they may merge at sentencing because they're really the same act of possession. But this is not a possession case. This is a case in which there are concededly separate assaults, and one of those concededly separate assaults, and only one, caused the death in this case. That's the homicide. And the other one could be an attempted homicide or an assault with intent to kill. but they are separate offenses for the same reason that they're separate assaults. So if there was a dispute in this case about whether these were separate assaults and that an argument that Judge Kravitz aired when he applied the fork in the road test. You know, that would be a logical argument that this was really just one continuous unbroken episode, and that would be true for both the murders and the assaults with intent to kill. But once you concede that once the government has conceded that there are factually distinct assaults, they have to be factually distinct homicides for all the reasons we gave in our brief.
So let me ask you, you just said something that made me think. I know it's not your place to tell the government how to charge its cases, but how would this case have been properly charged in the first place? Sounds like you're saying one murder or one homicide and one attempted, or could there be two completed separate murder counts charged in a case like this?
So there could be two completed murder counts charged in this case, and the jury could find the defendant guilty of both counts. One would be the completed offense, one would be a lesser included. But the government doesn't have to do that. They
By
can.
charging it that way, isn't the government essentially saying we can't prove this beyond a reasonable doubt?
Well, not necessarily. So they could, I mean, they could charge it in a single count like they did in this case. And you could have the instruction Judge O'Keefe came up with, which is sort of the catch-all that says, if you all agree that at no point in either incident was there self-defense or defense of others, and the mens rea was satisfied at all times, and we know that one or the other caused the death, that's sufficient for a guilty verdict. So the government says that instruction is required in this case, should be given in this case. Judge O'Keefe said he's going to give it. You know, we objected to it on double jeopardy grounds because we think that the Alabama Avenue homicide is out of the case. But if both those charges are properly before the jury, then that catch-all instruction is appropriate and permits the government to obtain a murder conviction, even if they can't say with certainty which shooting caused the death. In this case, they do say that they know which shooting caused the death. They say the Naylor Road shooting was almost certainly the cause of the death. That's what they plan to argue to the jury at the retrial. And so they want to have this sort of secondary fallback position, but that fallback position is unavailable because of double jeopardy. It was available to them at the first trial, and they chose not to pursue it.
Can I ask you, so it sounds like you think this was properly charged in the sense that, I mean, this indictment doesn't specify, you know, Alabama Avenue or Naylor Road. So you would agree it's not facially, in your view, there was a lurking duplicity issue, but it's not facially duplicitous. Is that correct?
Yeah, so when trial counsel first raised the issue, he sort of raised it as a problem with the indictment. I don't think that's not how I would characterize it now. I mean, I found cases that say duplicitous indictments are okay as long as you do something to cure the prejudice, which could be give a special unanimity instruction. So the government can actually.
But just,
Yeah.
you agree it's not facially duplicitous. You look at it and you can't say, oh, that's obviously duplicitous. Whether
Correct.
it is duplicitous depends on the evidence that's introduced at trial that suggests that under the rubric of this general language, there were
Yes.
two, in your view, factually distinct and conceded in some respects by the United States, factually distinct shootings that might be a possible predicate for the grand jury's finding. So it's not facially duplicitous, it's
Correct.
duplicitous only in light of the way things spun out of trial factually.
That's right.
And this also isn't necessarily directly a point that the United States is pressing, but it relates to some of the hypotheticals and how to understand them. Is it your sense that when jeopardy attached on, you know, so the jury is sworn and the opening statements start, is it your sense that that indictment charged both of those factual incidents, or what did jeopardy attach on in your view at the time? I mean, the indictment doesn't really tell you. It would be different if it was an indictment that said Alabama Avenue and Naylor Road.
Sure.
But it didn't. So what is your view about what all jeopardy attached to at the moment of this trial, given the general wording of the indictment?
So, I mean, we made the argument that jeopardy only attached on the Naylor Road shooting. And that was not based on the language of the indictment, but more about how the government had presented the case and its in the preliminary hearing and its motions and its opening statement. It kept saying the fatal shot was fired.
Well, opening statement is after jeopardy.
opening
After the
statement was
moment of
after,
jeopardy
right.
attaching. So I'm not quite sure how that, unless you think it, you know, it might be that the answer about what jeopardy attached to
Right.
is depends in part on subsequent events, but that'd be a little curious. But I mean, it's not impossible. So maybe that's your view.
Right.
I'm not
I
sure.
mean, I guess you could say that's what the government said in opening statement is probative of what it presented to the grand jury, which only the government knew.
And so is that your answer that if you have a facially non-duplicitous indictment and then an issue arises because of the way things spin out factually about whether there's a lurking duplicity question, the answer about what jeopardy attaches to depends on what evidence was submitted to the grand jury? That seems to be what you were getting at. I just want to make sure that is your position.
Yeah, so I think if the grand jury, if the government didn't present any evidence that there even was an Alabama Avenue shooting at the grand jury, and we knew that fact, then I guess you would say the grand jury only indicted on.
And it wouldn't be duplicitous and there'd be no implied acquittal if the government proceeded only on one of those theories, or even if it introduced evidence on both, but that was just jeopardy never attached to it. And then in your view, a successive prosecution on that other theory would be permissible?
That's what we argued in front of Judge Kravitz, and he ruled against us, and then Judge O'Keefe ruled against us. So the question of what jeopardy attached on has been resolved, attached on both shootings.
Well, I'm just trying to figure
Yeah.
out, I understand relative to the arguments that are being made,
Right.
what you're saying is correct, but analyzing some of the hypotheticals.
Yeah,
Like some of the hypotheticals about the government's view would lead to absurd
Right.
consequences, while yours doesn't. Depends on the answer to some of these questions about what
Sure.
happens, like what all jeopardy attaches to on
right.
a general indictment, because if jeopardy attaches to all homicides that
Mhm.
were factually distinct theoretical homicides that were within the wording of the general indictment, then I think some of your hypothetical answers would come out differently. So that's why I'm trying to make sure I
It
understand
could be,
the
and-
structure of it.
And to be candid, I do think there are cases out there that would say that, you just look at what the indictment says, and you're not allowed to go and look at that's actually what the government argued in this case, is that you're not really supposed to look at what the grand jury was told, but you just look at what the indictment says. So if the indictment says on or about X date, there was a murder, and on or about broadly encompasses. a
And my
long
point is,
time.
if that's correct,
Yeah,
then some of your hypotheticals, I think, would come out differently. Because if, let's say, the grand jury hears about a homicide that's based on actions of the defendant at time A,
right.
and the case, goes to trial on that only. And then later, the government learns, and there's an acquittal, let's say, or a mistrial or whatever. But, and then later, the government learns about a factually distinct incident that was on or about the same date. I
Right.
think your view would be, if that's the right way of looking at what jeopardy attaches, on your view as well, prosecution would be barred.
Um,
Because jeopardy attached on, any homicide, whether factually distinct or irrelevant, not
Right, so
relevant what the
yeah,
grand jury heard.
our view would be if one factually distinct homicide is charged and there's a separate.
No, but again, I'm not talking
Yeah.
about a typical
Okay.
indictment that isn't factually specific in that way, and instead of general language. And if you really can't look to what the grand jury learned, then I think the logic of your view plus that possible line of thinking would be that in these hypotheticals where you were thinking on your view, prosecution would be permissible, it really wouldn't be.
Well, I mean, if the government's view is that there's only one offense of murder, then anytime that offense of murder of a specific person is charged, it doesn't matter sort of what the facts behind it were. There's only one murder. So if you're acquitted of murder of one person,
No, I understand what
Yeah.
my point was, you were drawing a contrast between the consequences of your view and the consequences of the government's view.
yeah,
And I'm just saying that depending on the answers to some of these questions, I'm not sure that contrast exists. And that might be a logical consequence of both views.
I think it only exists. I mean, I guess it may in some sense depend on how we construe indictments, and you can on or about has been construed to cover a pretty broad time range, possibly months or even a year. So if you had two factually distinct homicides, say a week apart, and they're clearly factually distinct under, any conceivable notion of the fork in the road test, they would both be covered by the language of the indictment. Maybe the grand jury heard both of them.
Again, my hypothetical is they hear only one.
Okay.
And if you can't look back to what the grand jury heard, though, it doesn't matter. Both would be barred because jeopardy attaches on both.
Right,
That's anyway, I'm just trying to do that there. Can I ask you another question? A theme of some of your comments seems to be that the answer to whether these two hypothetical, one of them is a homicide, one of them is not a homicide, unless you have unusual circumstances where both bullets together combine to death in a way that would allow you to think of both of them as homicides, which is a possible scenario. But
Right.
leaving that unusual circumstance aside, so it's a little hard to refer to them as two homicides. But if you think of them as two alleged homicides, factually distinct, conceitedly factually distinct in some sense, alleged homicides. At times you seem to think that either they are different for all purposes or they are the same for all purposes. But I think you would agree that that's not quite right. I mean, you agree that at the end of the day, for double jeopardy purposes of multiple punishment, they are the same offense. Even though they are factually distinct, they are the same offense. No one could be punished for both of them.
I agree with that. I mean, there are certainly places where that's not true. There are other states where you can be punished for multiple homicides of a single person.
Under DC law, under DC law, the legislature possibly could legislate otherwise. But
Sure.
as we've interpreted DC law, at the end of the day, one victim, one homicide, one homicide conviction and sentence.
Yeah, so some
But they're the
states.
same offense under DC law for that aspect of double jeopardy.
Right, so I can imagine a scenario where you might say a person should be punished twice for two homicides of the same person, because you can be guilty of murder for both causing a death and hastening a death. So you can imagine a situation where you cause somebody's death, say by infecting them with an incurable disease that takes a year to kill them, and 6 months later, you're tired of waiting, so you do something to hasten their death. Those seem like two separate criminal acts that could both be conceived of as a homicide, and maybe there's uncertainty about your intent during the first one, and maybe there's some uncertainty about your intent during the second one. And so maybe one of those, maybe both of those are some degree of homicide, because they're both totally separate criminal acts deserving of punishment. It doesn't seem like just because you've put someone on the road to a certain death that you should then have a license to separately do something that hastens their death.
So just to be clear, you're
Yeah.
saying you think it's possible in a hypothetical like that, that a defendant could, at the end of the day, have, two separate murder convictions and consecutive punishment.
I think that's possible. Some states, DC doesn't have a ruling on this. Some states have what they sort of like a common law rule called the single homicide rule, that say even though two homicide convictions don't merge under a typical Blockberger analysis, we just think that, sort of one murder homicide sentence per death is enough as just a matter of sort of policy. DC doesn't have a case on that one way or the other.
Well, I mean, we have said a lot that,
Yeah.
at the end of the day, one homicide, one conviction. Your, I guess, argument is that we haven't confronted a scenario factually like the one that you're
Correct.
suggesting. So it would be possible to say, we've said that, but we really didn't say it in a setting where we might possibly reasonably think otherwise. Is that
Right, and the reason Byrd says that multiple homicide convictions have to merge is because they're the same offense. It's just felony murder versus premeditation. It's two alternative means of satisfying the malice element of first degree murder. So it's the same offense under a straightforward, maybe a not so straightforward Blockberger analysis, but that's the analysis. And then in the manslaughter cases, the court said they're factually inconsistent, voluntary versus involuntary. So the jury is told, return a guilty verdict on one, but not the other.
Yeah.
So yes, the court has not yet confronted the situation where there might be grounds for two separate homicide convictions of a single person, and one might be manslaughter, the other might be first degree murder, or some combination of the two. But I suppose it's theoretically possible.
And can I getting back to special unanimity for 1 second? I want to make sure I understand your position. So take homicide adds a layer of complexity. So stepping back into something simpler like simple assault, and imagine a case where the government's evidence, there's a single count of simple assault. The government's evidence is that the defendant punched the victim twice.
Mhm.
And the defense at trial is first punch never happened. That's false.
Right.
And then the putative victim, the complaining witness, punched me. And then the second punch was in lawful self-defense.
Yeah.
So they're, different defenses. That's all clearly you would agree that's one assaultive incident. That's not two factually distinct scenarios. Assume that happens within 5 seconds.
Right.
Is it your view, no special unanimity instruction because that is a single offense? Or, because I would have thought from our cases that those are treated as legally separate because they're different defenses to the two acts that could be the predicate for the simple assault conviction. But if I understand your argument about the relationship between special unanimity and double jeopardy, your view is no special unanimity instruction entitlement for the defendant in that hypothetical, unless I'm misunderstanding something.
No, there would be a special unanimity instruction required. So Horton's actually a similar case to that, except it's gunshots rather than punches, but it was that exact scenario. Defendant denied the first shot, claimed the second shot was self-defense. And the court
Right,
said.
and how does that fit with your view that you're only entitled to a special unitary instruction if the two offenses are different crimes?
Yeah.
The two incidents are different crimes.
Right, so they're different crimes in the sense that the jury might find one of them was a crime and not the other one, or the jury might find the opposite. So some jurors might think the first punch was the crime, but not the second, and other jurors might think the second punch was the crime and not the first, or some jurors might think both punches were the crime. So I actually think legally separate and factually separate boil down to the same thing, which is really, they're all just factually separate. And the difference is, are they factually separate based on the way the government has alleged the crimes occurred? So the government alleges one punch, a 5-minute break, followed by a second punch. Those could be factually separate if there's a fork in the road. Or they could be conceptually distinct offenses because of some evidence put on by the defense.
So to the extent you are treating the special unanimity principles and the double jeopardy implied acquittal type principles as the same, then does that mean that in the hypothetical simple assault case I just gave you, the way you look at it is that jeopardy attached to two separate crimes of assault, separate for purposes of duplicity, separate for purposes of successive prosecution and implied acquittal, but not separate for purposes of multiple punishment. I mean, I don't think you, maybe you do, I don't know, but you don't think at the end of the day in that hypothetical, if the jury thought, we don't agree with either of those scenarios, we find the defendant was guilty of an assault based on either of those two acts and both of them. You don't think there could be two assault convictions and multiple punishment, or do you?
Well, if they're charged in one count, I mean, that sort of simplifies it. If they were charged in 2 counts, then I guess they would still merge under the fork in the road test if the finding was made that there's no fork in the road. If the jury found so let's say the
So
jury.
those are, again, those are a single crime for multiple punishment, double jeopardy.
They're a single crime based on what the jury has found. Before we have the jury's verdict, they could be conceived of as separate crimes.
Well, no, assume, I mean, imagine that the case, imagine it was submitted to the jury. Imagine the charging document said, the defendant assaulted the victim by punching the victim twice. So it's a, very detailed, it lays out if there is a duplicity problem, which I will say I'm a little skeptical of in this setting, but if there were, it's right on the face of the charging document. And then the jury is given a special unanimity instruction and the jury returns a verdict, which says we find that the defendant committed assault in the first punch. And also it was the second punch itself also was sufficient to be an assault.
Right.
Would you say, multiple, two simple, if complication, if it's charged in a single count, but imagine it's charged in 2 counts, let's say instead, you would say, are you saying that not multiplicitous to charge it that way and 2 simple assault convictions at the end of that trial?
Potentially, again, it sort of depends, like the jury can be presented with multiple theories, right? There could be a theory under which the jury.
No, so again, I apologize because it was shifting hypothetical, but
Okay.
to walk through it again, imagine there's a 2 count information charging simple assault. First one says defendant punch the victim at, and has an exact moment in time and there's a video of it. And then the second one is the defendant punched the victim 3 seconds later.
Right.
Clearly alleged in the charging document and information, probably, if that's all that was going on. And then the jury, that gets tried and the jury returns a verdict, finding guilt beyond a reasonable doubt on both of those, notwithstanding the defenses that I mentioned. Are you saying at the end of the day, the multiple simple assault convictions are permissible and, separate punishment? Or are you thinking that's all a single assaultive incident that is the same offense for multiple punishment purposes, even though maybe it isn't for some other purposes?
I'm saying it may or may not be a single assault, depending on the jury. If the only thing.
I mean, I've told you what the jury's verdict was and what the evidence underlying it was.
So imagine we give
what matters.
So suppose we give the jury a special interrogatory that says, do you find these 2 assaults were separated by?
Well, no, these are separate counts. So each one of them, the jury has found beyond a reasonable doubt, that one was, sufficient as against any defense to.
Well, the court has cases where people are convicted of multiple counts and there's an argument made that those multiple counts merge. And sometimes those arguments win and sometimes they don't, and they're dependent on.
I get all that. I'm
Yeah.
just trying to figure out whether, if you take the facts as I'm describing them, whether your position is that at the end of the day, a defendant in a case like that can be punished for 2 assaults or only for 1.
If the only reason they're charged separately, maybe this is what I'm missing. So the only reason they're charged separately is because of the 2 potentially different offenses.
I'm not sure it matters what
Okay.
the subjective thinking was for the reason for the separate charges, but if it did, let's say yes.
Then I think they would merge because there's no allegation that they were separated by a fork in the road. But imagine the scenario where they're charged in one count.
And
Yeah.
the point being, if that's right, if they do merge, the abstract point is sometimes offenses are the same for multiple punishment purposes, but are different for purposes of things like special unanimity. It seems to me that that's what follows from that answer.
Well, I think the key point that I want to make is that until we have the jury's verdict, there's a conception, there could be all sorts of disputes, and depending on how the jury resolves those disputes, there could be two factually distinct offenses, there could be two legally distinct offenses, there could be one, homogeneous, continuous offense. So when we're in the midst of trial and we don't yet have the jury's verdict, we have to decide, are these conceptually distinct offenses? If so, you have to have a special unanimity instruction. And suppose we had, a special verdict where the jury says, we think the second punch was in self-defense and we can't reach a conclusion, or we find him guilty of the first punch. If there were then a retrial, I don't think there would be any grounds to dispute that the government would be barred by double jeopardy from re-prosecuting on the second punch, because that was a conceptually distinct offense that the jury found did not occur.
Isn't that the government's very argument here? I mean, at least as with respect to jurisdiction, as to why this is interlocutory, let it play out and see what the jury decides.
No, because they concede that the court has jurisdiction and should reverse the denial of our motion as to the assaults with intent to kill. And the Supreme Court has said, for jurisdictional purposes, or for double jeopardy purposes, we don't care whether they're charged in one count or conceptually distinct offenses within one count. If they're conceptually distinct offenses and there's been an express or implicit acquittal, then you have a right as the defendant to not be retried for that conceptually distinct offense on which jeopardy is attached and terminated, regardless of whether it's one count or two. That's in Sanabria v. United States, 437 U.S. 54 at 69 note 23. And there was actually the reverse position where the government was appealing, what they were challenging was not the dismissal of a discrete count, and there was a statute that says the government can appeal from the dismissal of a count. And there was an issue about whether what they were doing was appealing the dismissal of a count, and the court said it doesn't matter. Unless the court has any further questions, my time has expired. So we'd ask the court to reverse.
We'll give you a couple of minutes in rebuttal.
May it please the court, Timothy Cahill for the United States. It's undisputed that there's no jurisdiction for interlocutory review of appellant's murder claim if he's charged with only one murder in this case. And it's well established that the killing of one person is only one instance of murder. I want to begin by addressing something that was discussed a lot during appellant's argument, which is the relevance of the special unanimity instructions here. This court's case law is clear. The special unanimity instructions are not limited to curing duplicity. The Brown case is not muddled. It was undisputed in the Brown case that the charge was a single crime. And in fact, in Brown, this court said that ordinarily that would mean there's no unanimity problem. However, because different legal defenses were asserted to different factual means of a single crime, a special unanimity instruction was proper. That makes clear that these are not synonymous inquiries, that the presence of a special unanimity instruction or the use of unanimity instruction does not inherently mean that there's duplicity.
Why does that matter for jurisdictional purposes?
Well, because appellant has argued that our acknowledgement that a special unanimity instruction may be appropriate here is somehow a concession as to duplicity.
I
But-
thought the defense's argument or appellant's argument was, look, they conceded, or they said they were, once this issue arose in the trial court, the government said it was only going to proceed on the murder charge on the Naylor Road shooting. And they abandoned the charge of murder on the Alabama shooting. And so therefore jeopardy attaches and they can't go back and revive the Alabama shooting now on retrial. I thought that.
And with respect to the murder charge, Your Honor, that could only give rise to interlocutory appeal. Any preclusive effect there, which I know the parties dispute whether there is any preclusive effect, but to the extent there could possibly be any, it can't be resolved in interlocutory review unless it results in either the dismissal of an entire indictment or an entire charged offense.
But you've conceded it as to the assault with intent to kill. So your argument can only now be that homicide is sui generis, right? For even just for jurisdictional purposes.
So Your Honor, I think it's well established in that the nature of an offense affects when means become so distinct as to be separate instances. There's lots of cases, and we cited a number of them, where in the context of murder, things are viewed as different means, even when they're far more factually.
I mean, we're getting
distinct.
into the merits of your argument, so I guess I just want to be clear. It seems like your jurisdictional argument collapses into your merits argument, right?
I think it collapses into the
There's
duplicity.
no jurisdiction if the indictment, if there's no double jeopardy bar, but if there's a double jeopardy bar, then there is jurisdiction.
I think it's a little bit more, to be more precise than that, Your Honor, I think it collapses into the duplicity analysis, not whether there's any other potential argument based on some sort of collateral estoppel theory about preclusive effects of what happened below. I think the duplicity question is what's critical to the jurisdictional question. If there's no duplicity here, if there's only one murder charge, which we believe to be the case.
I'm sorry, maybe I'm missing something, but why doesn't that just gloss over the government's decision at the first trial to abandon the Alabama shooting?
Because if there's only one murder charge, which we submit, the case law is clear that there is only one murder here.
But it doesn't matter. But what if the government was wrong, right? I mean, I thought that's what Evans was, right? What if the court and the government was wrong to make the election?
So
It doesn't jeopardy still attach? Or isn't this still appealable? I'm totally confused by the government's argument.
I'll try to start with basics then, Your Honor. There's only interlocutory jurisdiction if the successful appeal could result in the dismissal of an entire charged offense.
We're hang up on the word charge. You agree if two offenses that are separate in law are in a single count of an indictment, and the defendant says that the double jeopardy clause bars one of them, which is a separate charge in law, though it was in a single charge that the defendant is arguing is duplicitous in a charging document, that there's jurisdiction to assess whether the defendant is correct, that although there is a single charge here, there should have been two, and the defendant is seeking through the interlocutory appeal to bar trial on one of them. Is that true?
I would agree, Your Honor. We're not arguing that the form of the charging document controls. We're arguing that there is in substance here.
And that has to be true because you conceded interlocutory jurisdiction over the AWIC, which had the AWIC charge, which had the same form.
That's correct, Your Honor.
And just to be clear though, so is it right that you agree that we have jurisdiction to decide the correctness or not of the defendant's argument that the charging document here with respect to murder is duplicitous because for purposes of assessing duplicity, the Alabama Avenue shooting and the Naylor Road shooting are distinct homicide offenses. We have jurisdiction to decide that question and figure out whether it's correct or not. Do you agree with that or not?
I mean, I think effectively, yes, Your Honor, the way I would frame it is a little bit different. I would say that this court needs to resolve the duplicity question to determine if it has jurisdiction to assess whether there's a double jeopardy bar. And if the duplicity question
I
results
thought
in.
some of our cases were a little, I'm not sure a ton matters because however you characterize it, if the answer is we need to decide that question and we can decide that question, then that may be all we need to know. But I thought there were some cases that said that where a defendant is bringing an interlocutory appeal and raising a double jeopardy claim, if that claim is colorable, then the court has jurisdiction to decide it on the merits interlocutorily. So I would have said that a little bit differently, but do you agree with that? Or you think that actually there's only jurisdiction? In other words, if we disagreed with your opponent and said no duplicity, you think our disposition of the case should be dismissal for lack of jurisdiction rather than saying we had jurisdiction over a colorable double jeopardy claim and now we're resolving it adversely to the defendant on the merits.
That's correct, Your Honor. I would say note that I feel like this court actually
But
addressed this.
just to be clear, I gave you two alternatives, so
Oh.
that's correct. It's a little bit confusing to me.
If this court determines that there's no duplicity, then we believe it should be just the appeal should be dismissed with regard to the murder claim for lack of jurisdiction, because this does not raise a double jeopardy claim that would result in the dismissal of a charged offense.
Are you familiar with the cases that I'm referring to that talk about kind of interlocutory jurisdiction over an interlocutory appeal raising a colorable double jeopardy claim, or are you not familiar with them, or you think they're not applicable, or you think I'm
I'm familiar, I believe we addressed those, Your Honor. To the extent that they say that there's interlocutory jurisdiction for a colorable claim, we don't believe that there's a colorable claim here, that there's a dismissal of an actual charge at issue.
Well,
if you're-
right, so I think you are right that if we ended up saying not only do we disagree with the defendant about the claim of duplicity, but we really so strongly disagree that we don't even think it was ever colorable, then I think you're right. We should, our disposition should be dismissal. But if we thought, well, it's a colorable argument, at the end of the day, we resolve it unfavorably to the defendant, I would have tended to think we had jurisdiction and we should be deciding the case on the merits. But and it sounds like perhaps you agree with that or not.
I don't agree with that, Your Honor. And I would say in the Jones case, this court expressly said that even if there's an argument about some preclusive effect of what happened below, if the defendant still could be convicted of the charged offense that he's challenging, then it's not grounds for an immediate appeal. That this court doesn't have jurisdiction to resolve that.
But if we have to decide the duplicity question, then we have to touch on the merits, in which case we are essentially exercising our jurisdiction to address the merits. So whether we ultimately disagree with the defendant and our choice in the resolution language of our opinion is dismissal versus affirm, doesn't really make a difference at the end of the day, right?
I mean, if ultimately this court rules in our favor and frames it differently than we're framing it, of course I wouldn't object. I would disagree, though. I would view the duplicity as a predicate to determining jurisdiction,
But
not as because it's distinct from the question of whether or not there are other types of preclusive effect that about theories and arguments that would fall under the umbrella of collateral estoppel that can be litigated in trial courts and that can be litigated on appeal, but not an interlocutory appeal. And to the extent, to circle all the way back to Judge Easterly's questions at the outset that I was hoping to clarify, to the extent that the court agrees with us that there's only one substantive murder charge here, appellant's arguments all sound in the question of whether or not the government is allowed to pursue certain factual theories underlying that one charge, that one offense. And those types of arguments are not subject to interlocutory appeal. Those are to be determined with the scope of a full record, with the benefit of a full record of the actual evidence presented at trial, arguments presented at trial, jury instructions, and verdicts. They all fall under the umbrella of collateral estoppel. And this court made that clear in the Jones decision, and we cited a number of cases from other federal courts of appeals. I would note the Ozen case in the Fifth Circuit, where that court even found that they acknowledged in that case that they felt like the preclusive effect of certain verdicts at the first trial were pretty clear cut about an issue of collateral estoppel, about which theories the
I'm not
government
sure your
pursued.
opponent is disputing any of that. I think that I at least don't recall them arguing that even if there's no duplicity here, there's still an interlocutory double jeopardy appeal. So it seems like the more salient point, I was going to say moving off jurisdiction, but the relationship between the merits and the jurisdiction is so tight that it's hard to know whether we're moving off it or still continuing to explore jurisdiction. But is it your view that it's impossible to have a duplicitous homicide count involving a single victim?
I would say that in terms of whether or not, so I'm going to answer your question, Your Honor, but I think one thing that's important to distinguish here conceptually is whether or not we're talking about legally distinct offenses, which is the sort of thing this court addressed in Byrd, or separate instances. The Newell case in the First Circuit talked about these, and they're interrelated. And so to answer Your Honor's question, I don't believe there could be duplicity based on separate instances of murder where there's only one victim.
But there could be other forms of duplicity.
I would say no, but to the appellant's point, there are some jurisdictions that have said, for instance, that contrary to this court's binding precedent, I would say in this jurisdiction, no. But say in Alabama, if for instance, that you're allowed to charge felony murder and first degree murder separately in this jurisdiction, those aren't separate crimes. In some jurisdictions, if they are, that's a separate issue. Those are legally distinct offenses. But it's separate instances of murder.
Well, your opponent argues, apropos of this, possible duplicity in certain areas. Your opponent in the reply brief cites an old case of ours called Bradford, which held that it's duplicitous to charge voluntary manslaughter and involuntary manslaughter in a single count. And that seems to be inconsistent with the idea that you can never have duplicity. There's only one homicide. It's impossible to have a duplicitous indictment that charges a homicide, involving a single victim.
And so again, Your Honor, I think that would fall under the umbrella of this question of whether those are legally distinct offenses.
And why do you think if a homicide, I mean, the simple slogan is like one homicide, so no duplicity, because no matter how many different ways you charge someone with it, it's all a single crime at the end of the day. That, I get that, that's a simple slogan, I can understand it. It's a little harder, the slogan, which is one homicide, but you can't have duplicitous indictments if the legal forms of the homicide are different in some ways, but you can't have duplicity if the differences are factual in character.
And that's why
What's the
think
basis
this-
of that slogan? It's a little harder to get the rationale for.
I understand, Your Honor. I think that's why I would simplify it to say that when there's only one victim and one killing, that's only one instance of murder. It's only one instance of homicide.
Well,
Even
there's
in the
one
case,
instance of homicide in Bradford. One victim dead, I think I don't think it had much factual distinction. So it's like a single factual incident, one victim, two different homicide counts required. So why?
but it's still only one instance of homicide, Your Honor. The victim,
I
the
get
defendant couldn't have possibly been convicted of both.
I get that, and
Right.
that's my point, is we said in Bradford, you have to have two separate counts here, and a single count would be duplicitous, even though it's one instance of homicide. One instance of it, but nonetheless, you have to charge it twice. And why, I just can't understand why we would say that, but we would say if you have factually distinct scenarios, that you always permissibly can, in fact, only could, I gather on your view, charge it once.
Because the question is a little bit different as to whether, if they're legally distinct, you're looking at whether or not the elements overlap. When they're if the question is whether there's different instances, you're looking at scenarios where factual means become so distinct as to be separate instances of the same crime. And when that happens varies based on the nature of the crime. And in homicide cases and murder cases, the cases that we've cited have consistently found that even when different means, different factual means, different specific acts that may have caused the death are very factually distinct, they're still viewed as different means, not as different instances of murder. Even if it's so different as, for instance, charging the defendant with fracturing the skull of the victim or giving an overdose of medication.
But so you're saying the same conduct can constitute different means for purposes of a homicide charge, but different offenses for purposes of assault with intent to kill?
Absolutely. Just as in the case, in some of the Shad scenario, the Judge Scalia describes, if, or even to choose a very tragic case from our local jurisdiction that we talked about as a hypothetical for these concepts, the Wint case here, where you have victims
The Wint
that were.
case was a continuous course of conduct, wasn't it? That's the way it was charged, right?
But to the point that if there's charged as a in the context of homicide.
There was no attempt to say, oh, well, we think the person was killed at this point, or maybe they were killed at this point. It was just, the house was kind of a black box. They didn't quite know when people died, but they died, right? And that was how the government chose to try it.
But under the defendant's theory that a specific act, there needs to be unanimity as to a specific act, it would have been, the jury would have had to have resolved which specific act caused the
I don't
death.
think your opponent's argument is that it's a specific act that is required. I thought their argument was, and that the way they attempt to distinguish a number of the cases you're relying on is to say those are all cases where there may have been separate acts, but they were all part of a single assaultive incident rather than, as seems to be conceded for current purposes in this case, two distinct criminal incidents. I thought that was your opponent's argument.
I believe that, I mean, there was also certainly language in appellant's argument about the unanimity for specific acts. We certainly don't agree with that, though, so I'm not going to make that argument for them. But I would note that.
Maybe so. So the cases that you're relying on, to the extent your opponent is relying on the idea of each separate act giving rise to concerns about duplicity, those cases would be a pretty good response. But to the extent they at least also, in fact, I think primarily argue that whatever may be true, when you have separate acts that are in a single assaultive incident, isn't necessarily true if you are talking about acts that are separated by enough in space and time and other circumstance, and fork in the road and other metaphors, to be separate criminal incidents. And do you have cases in your view that address this question of duplicity or some of the related topics in contexts where that involve what were understood to be or what we would naturally view as distinct criminal incidents rather than kind of all part of a single assaultive incident?
So I'm not aware of a case that specifically has framed it that way. I would note that I don't believe appellant has cited those either. I think that this is not, I don't think this issue has usually been framed this way. This is a somewhat unusual scenario. I would note that in the cases we're relying on, the means were even more factually distinct than we have here. We have instances where somebody, again, the Robinson case from Kentucky, I would note, the allegations were that there was evidence that the victim's skull was fractured and that an overdose of medication was given, potentially over the course of an entire day. There's under a fork in the road test, certainly those would have been factually distinct, and certainly they could have been charged as separate crimes, separate assaults. There's no doubt that those would have been separate assaultive incidents in the same way that we can see the AWICs here, or at least we're no longer challenging Judge Kravis's ruling below that the AWICs here are separate incidents. But for purposes of homicide, where a homicide is only completed with the death of the victim, those are different means for achieving that. And the nature of the offense is relevant for deciding when those different means get so discrete as to be separate crimes.
And so would you agree that in a case with perhaps a starker break in the chain of events than here, maybe 30 minutes, but two shootings, maybe through a closed door, no one knows which shots killed the victim, the government could not charge murder and attempted murder?
Well, attempted murder is different, Your Honor, because attempted murder doesn't require, for its completion, the death of the victim. Where we're
Right,
the
but
killing
they-
of the victim.
But you would agree that they would merge?
But I mean, if you don't know which shot killed the victim in the black box, if the victim's already dead, charging them with attempted murder would seem not to fly. I mean, I'm just.
I mean,
not
as
understanding.
as a matter of proof, Your Honor, if the government couldn't prove, if there wasn't sufficient, so to go deep down in this particular scenario, if there wasn't sufficient proof that the victim didn't die as a result of the first set of shots, then the second set of shots, then I think they probably could not, they would have to merge because there couldn't be an attempted murder for shots when the victim was already dead under that very specific scenario where it wasn't clear where they died. But regardless, the significant thing for purposes of this case is that there would be a single murder charge there. The fact that there were two separate shootings there would be separate possible factual theories as to how the murder occurred and when it occurred. But it would still be one charge of murder based on one killing of the victim.
Can I ask
And
you,
if the jury,
we're back. Let me ask you a hypothetical that to a degree goes back to legal differences between forms of homicide. But imagine a case where the government indicts the defendant for felony murder, robbery, and felony murder burglary. Let's say arising out of a set of circumstances that takes a little bit of time, and at the end of the day, it's a single victim, same victim is the decedent in both counts. Part of this is an implied acquittal question, but so imagine that during the course of the trial on that, at some point, for whatever reason, either the government elects to proceed on only one of them, or that everybody forgets about one of them and no verdict is returned. So let's say a verdict is returned only on felony murder or robbery, and no verdict is returned on felony murder or burglary. And let's say that, or let's say that, let's say that verdict is an acquittal, and then the government wanted to possibly retry on felony murder or burglary. Would you agree that that would be foreclosed by double jeopardy principles because that account reflecting felony murder, burglary had been submitted to the jury and no verdict was returned, and not even a hung jury, but it was just either the government elected not to proceed on it or for whatever other reason, it got lost in the shuffle. Would you agree, or barred or not barred?
under collateral estoppel, that would be barred, yes.
No, why would it be barred under collateral estoppel?
Because-
What if the jury, if one of the arguments was there was no robbery? Jury might well have acquitted a felony murder robbery on the theory that there was no robbery. I don't see that there'd necessarily be a collateral estoppel issue.
And maybe I missed out, Your Honor's missed part of the hypothetical. I thought that there was an acquittal as to felony murder.
Right, felony murder
robbery.
robbery, if the reason for the acquittal was,
I
wow,
see.
there's a debate about whether there was an actual robbery. I don't see the collateral, I mean, there might be a collateral estoppel problem depending on how the case was tried, but there wouldn't necessarily be. I'm asking whether there's an implied acquittal, independent of collateral estoppel.
I think I would actually stick with it that in that scenario, that would have to fall under the umbrella of collateral estoppel because it wouldn't be an acquittal of a full charge. It would be an acquittal of a theory.
It is a full charge, certainly.
It wouldn't be an acquittal, maybe I should be more precise. It wouldn't be an acquittal of an entire offense. Because under this court's case law, those are the same, the two different theories of felony murder are different means of the same offense, a different means of proving the same offense. So if anything, it would be collateral estoppel that the government would be
So
precluded.
you're saying if barring collateral estoppel, it would be fine for the government to submit both of those counts and then in the middle elect not to proceed on one and then start up again on that same one later?
So to be clear, it wouldn't be fine. Collateral estoppel can preclude the government from doing things. It wouldn't be
I'm
grounds
assuming
for.
here, I'm assuming here there isn't a collateral estoppel bar because the most natural explanation for the acquittal in the first count was uncertainty about whether there was a robbery.
I would still think it would fall under collateral estoppel in terms of the government, the theory available to the government if the jury conclusively determined that there was insufficient proof on that theory. That
Understood, but could they proceed on felony murder burglary? Is my question. I
where
understand.
there
they
was
can't-
not an acquittal,
There was no verdict one way or another.
then yes, absolutely. That would be a classic case of a hung jury where
Well, no, there's no
there could be
verdict.
retrial.
There's not a hung jury. There's just no verdict. Either the government elected not to proceed and it wasn't submitted to the jury, or people forgot and it wasn't submitted to the jury.
Well, I think in that case, certainly the government would argue that we could proceed. There might be some litigation on whether or not there was an implied abandonment. I think that might depend on the specific facts of the case. But
Let's assume there was an explicit abandonment. You would say it's fine to go ahead and indict somebody on felony murder burglary, submit it to the jury, or start the trial on it, go through part of the trial, elect not to proceed on it, and then just start up again in another trial. As long as collateral estoppel doesn't bar it, it's fine as far as you're concerned. Is that right or not right?
I don't, I think that would hinge on the specific sequence of events that played out in terms of, I think it would still fall within collateral estoppel because we're talking about a specific theory of the case. It would depend on whether or not the government's stopped from presenting the case based on that means. It would not be an entire charge. It wouldn't give grounds to an interlocutory appeal for dismissal of an entire charge, which is the only issue before the court here we would submit in terms of the murder claim. But if anything, if there's any preclusive effect, it would be based on the prior verdict. You know, that could fall under collateral estoppel theory. I think I would point to the Ozen case in the Fifth Circuit. I think that there's some it's somewhat analogous to your Honor scenario, where there was a first trial, there were a number of verdicts on other charges that weren't at issue. And there was an argument that those verdicts should have precluded the government from proceeding on retrial on 2 of 3 theories of liability for a charge that was remaining, that it was indisputed that they could retry on. And the dissent actually urged the court to find, because it felt like that was a clear-cut issue of collateral estoppel, it urged the court to find on interlocutory appeal that the government couldn't pursue those. And the majority correctly, in our view, determined that it just didn't have jurisdiction to decide that.
Yeah,
That
my
there was no
question is really,
dispute
the
that the
jurisdictional
charge
question
could
is
be
an
retried.
add-on, but my question isn't really about jurisdiction, because I was really asking, is it lawful in the trial court for the defendant, for the trial judge to permit such a reprosecution, or would it not be lawful? So it's an added issue to say, would there be interlocutory appeal?
In general, in a retrial where all that's being changed is a theory of liability, where there wasn't an actual charge that was abandoned or dismissed, I think the government would be permitted to pursue.
And by actual charge, you mean not the way the indictment is structured, but a
As
charge
a
that is
legal,
distinct
as a
and
substantive legal matter. As a substantive legal matter, this like what was something that was a singular charge, a singular offense, maybe is the best way to phrase that.
And you think the same is true about involuntary manslaughter and voluntary manslaughter? So if a defendant is charged in 2 counts of the indictment, consistent with what Bradford requires of involuntary manslaughter and voluntary manslaughter, and the jury, the government explicitly elects during trial, you know what, we indicted both, but we decided we're going to put all our eggs in the basket of voluntary manslaughter, and the jury acquits. You'd say no problem with retrial on involuntary manslaughter.
Well, if there's an acquittal on something that's a legally discrete offense, then that acquittal would bar retrial on that offense. It
Right, but
wouldn't
not
bar-
on involuntary manslaughter.
Not on the other offense if there was no verdict, no. See, I'm out of time. If the court has no further questions, we'd ask that the claim regarding the murder charge be dismissed or rejected, and that the case be remanded with regard to the AWIC charge as we describe in our brief. Thank you, Your Honor.
Thank you, counsel.
So Mr. Cahill argued, these are different means, these 2 shootings are different means of committing the same murder, but we're beyond different means here because there's a finding that's undisputed that these were distinct offenses for purposes of assault. And if they're distinct assaults, they logically have to be distinct murders. just as if we were to take the Commonwealth v. Sear or Shad v. Arizona hypothetical and assume that the victims in those cases survived, there would be one attempted murder, not multiple attempted murders. It's the same logic, that the same distinction between means and offenses. And if to hold that homicide is sui generis would lead to logical absurdities in this very case, including that Mr. McClam could not be convicted of even simple assault, but he could be convicted of the offense of murder, even if the jury doesn't unanimously agree that any single shot he fired was unjustified, was a criminal act of any kind. He could still be found guilty of murder.
Why does that, I think you made this point in your brief too. It has it seems like a certain simple logical structure to the idea that if, imagine, if you think that the homicide count here, which again didn't speak specifically to Alabama Avenue or Naylor Road, but if you think that it charged as a lesser both of the AWICs, the AWICs at both locations against both victims, so probably 4 AWICs if you're multiplying them all. In a way, the indictment has to be, that proves the indictment, the murder count is duplicitous because it's a single count, but we know that it charges factually distinct and legally distinct and double jeopardy distinct in all purposes, including for some possibly multiple punishment purposes, distinct AWICs. But I don't think that's, I don't think it works that way. I mean, if you think of assault with a dangerous weapon, it has 2 lessers, a simple assault, and so it's a single count, but it has 2 non-merging lessers. So it's not, there's nothing structurally impossible for the idea that a count that is not duplicitous contains within it lesser included that are separate and separately punishable. So I'm not quite sure that it follows as readily as your line of thinking suggests, that the separateness of the included lessers implies the duplicity of the greater.
I think it does, because it is logically impossible to say that if a jury can convict on the greater offense, it couldn't convict on the lesser included offense. And here I'm talking about a situation where the jury could not unanimously agree on any lesser included offense of murder, but they could return a guilty verdict on murder. So that's the absurd result. They don't think he committed even an assault, but they could say that he committed, the offense of murder. That's the absurd result. We also pointed out what I call the Schrodinger's cat scenario, where there's a question about whether 2 distinct factual assaults caused a murder. And in that scenario, the jury's verdict would depend on the order in which they consider the elements of the offense. If they consider causation first and decide, yes, the defendant caused the decedent's death, then they could find the defendant guilty of murder, even if they're split on which assault caused the death, because they don't have to be unanimous on means, according to the government. But if they put causation aside and say, let's first decide if he even committed any assault, and then we'll decide if the assault caused causation, they might be hung on whether either assault was actually justified or unjustified. So that's another absurd result. It doesn't make any sense. When you're talking about a lesser included offense and the greater offense, where the only additional element is that, the assault caused the death, it doesn't make sense to call the incidents different means of committing one murder, but different completed offenses of attempted murder or assault with intent to kill. And the other problem with the government's theory in this case is, let's say they did actually want to convict Mr. McClam of both completed murder and attempted murder of KB, not just the AWICs of the 2 surviving people in the car. Theoretically, they could do that based on Judge Kravitz's finding that these were 2 distinct assaults, but how would we, but they would have to merge if there can only be one completed offense of murder. So you have to have some ability to distinguish homicides from one another factually. The fact that a person can only die once is maybe a reason why ordinarily there's only going to be at the end of the day 1 non-merging conviction for completed homicide, but that doesn't tell us anything about whether they're conceptually distinct offenses, which takes me back to Scarborough. Now, this court has a number of post-Scarborough cases questioned the logic of Scarborough. I think, there's an open question about whether Scarborough was rightly decided. The government's not asking the court to overrule Scarborough. Scarborough says legally distinct and factually distinct offenses are the same thing. There's no principled basis. That's a quote from Scarborough, no principled basis to treat them differently. I think the gist of it is the government does not have a monopoly on deciding what is two distinct offenses versus one distinct offenses. And initially, when they charge it, they can say, we think this is one offense. But if the defense puts on evidence that there are two conceptually distinct versions of that offense and the jury finds the defendant not guilty of one of those conceptually distinct offenses, that has a double jeopardy impact. For example, this goes back to some of the questions you were asking Mr. Cahill. I imagine that if a defendant, as is typical, is charged in count one with premeditated murder, count two with felony murder, if the jury says not guilty of premeditated murder, guilty of felony murder, and then there's a reversal and a retrial, I don't think any prosecutor would get up and argue and say, well, we're not double jeopardy barred from re-prosecuting for premeditated murder, even though the jury previously acquitted.
Well, they have a collateral estoppel problem, even if there wasn't an implied acquittal or
Well,
other
some-
kind of problem, but
some
to that
people-
one, I'm not sure.
Some people question whether there is a collateral estoppel component of the double jeopardy clause, but I don't think anybody would question that that acquittal is jeopardy barred. This is the exact same case, except the acquittal is implicit rather than explicit, but the Supreme Court has said a number of times that doesn't matter. So under Evans v. Michigan, even if you think Judge Kravitz made an error when he said these are duplicitous homicide charges, it's no different than if he had submitted to the jury, two verdicts, find him guilty of the Naylor Road homicide, find him guilty of the Alabama homicide. We had an express acquittal on the Alabama homicide. Here we have an implicit acquittal, but that's just as good for double jeopardy purposes. So unless the court has any further questions, I'd ask the court reverse.
Thank you, counsel, for your arguments today. We appreciate your time. The case will be submitted. Now Judge McLeese is going to leave us.
All right.
And you can have a seat. The second case on our calendar today is 23 CV 552 Fransuelo Russell versus DC Department of Public Works et al. Counsel, when you're ready.
May it please the court, Claire Homsher for appellant Fransuelo Russell. I'd like to reserve 3 minutes for rebuttal time. Ms. Russell asks this court to remand to the OEA for further proceedings because the OEA failed to examine whether DPW rationally and conscientiously considered the Douglas factors before deciding the appropriate sanction for Ms. Russell's first-time positive marijuana test. Douglas makes clear that an employer must undertake, as relevant here, 2 distinct inquiries before taking adverse action against an employee. First, does the employee's conduct merit some sanction? And second, if so, what is the appropriate sanction based on the specific individual considerations? DPW does not dispute that before taking any adverse action against an employee, it must rationally and conscientiously consider the Douglas factors. But DPW did not do that here. And importantly, nowhere in its briefing before this court does it claim that it did.
Counsel, sorry to interrupt you, but can we start with the timeliness question and the question of dismissal versus denial? it's clear, I mean, the language is not entirely clear in the trial court's order, but certainly the trial court said that the motion is indeed untimely, and then said, even assuming it is not, I'll proceed to address the merits of the case. You seem to be hanging a lot on the fact that the trial court ultimately didn't use the word dismissal, but used the word denial, and I'm curious where, if you have any grounding statutorily or regulatorily for the import of that word.
Sure. Yes, Your Honor, we cited a couple cases. They're not from this jurisdiction, but there's a Fifth Circuit case, Spear v. Quarterman, that's in our reply brief at page 7, that says a denial signifies that we addressed and reject the merits of a particular claim, while a dismissal means we declined to consider the claim for reasons unrelated to the claim's merits.
No, I get the difference between the two. But what would preclude us from saying, well, it's quite clear the trial judge both thought the claim should be dismissed, the petition should be dismissed and denied. It's clear, her language says that it should be dismissed in a couple sentences just above where Judge Shanker was quoting. So, what if, well, let me ask the question slightly differently. If you look at the last page of the order, when she says that the petition is denied, if she had said is dismissed, what's your argument that there was any error in that?
I don't think she did say it was dismissed, Your Honor.
That's right. I mean, she definitely didn't, but nothing stops us. What's to stop us from vacating this and remanding with instructions to use the word dismissed consistent with the trial court's reasoning?
I think I want to go back to what the factual circumstances of what happened before the Superior Court were. So she did timely seek review of the OEA Board's decision in the Superior Court in some fashion, right? The OEA Board's decision was issued on April 22nd, 2021. 30 days after that was a Saturday, May 22nd. So that gives her till Monday, May 24th to file something. And on Sunday, the 23rd, she filed. And again, she was a pro se litigant at this time. She filed a complaint in the Superior Court, and the complaint requested, this is a quote, look at all facts and judgment and paperwork that was submitted. She also attached a separate one-page statement explaining that she had appealed DPW's termination decision to the OEA Board. The OEA had denied her appeal, and she was requesting that the adverse action be reversed. And she attached the OEA Board's opinion to that. So yes, she did that on the wrong form. It says complaint at the top. It doesn't say petition for review of agency order, but I think the substance of what she wanted was clear. And it was November of 2021 that the DPW filed a written motion to dismiss her complaint. 10 days later, again, still acting as a pro se litigant, she filed a petition for agency review.
So I'm sorry, I don't mean to cut you off again, but it seems like you're forming an argument that all of those would have been grounds for equitable tolling of the timeliness requirement. And that's probably right, but that was never presented to the trial court. And even in response to a motion to dismiss by the government. And so, I mean, how are we to assume that the trial court should have and would have equitably tolled when those things were never presented to the trial court?
Yes, I think as you mentioned, the Superior Court's decision is not abundantly clear, but given those facts and given that there's no language saying that she was going to dismiss the petition for untimeliness, she did go on for some time to address the merits of Ms. Russell's petition. I think that there's an inclination to address cases on the merits. This court has held that. We think that's exactly what the Superior Court did, and that's what we would ask that this court does as well.
I think what Judge Shanker is getting at, though, is Ms. Russell was counseled after there was a motion to dismiss the petition for being untimely. There was no argument. It strikes me that there are a couple of different arguments were available to Ms. Russell at that point. She could have argued the motion to dismiss was untimely. They sat on this for too long, several months, I think 6 months, if I'm not mistaken. She doesn't make that argument. The second argument she could have made was equitable tolling, because she has some pretty good facts here that you've laid out, but they don't make that argument. And of course, equitable tolling is something that's on the burden of somebody asserting it to come forth with some facts to support. So having failed at that, Forget about what the trial court said here. How could the trial court have done anything other than dismiss this petition as untimely?
The rule is not jurisdictional, so I think she did have discretion to consider the merits rather than.
Well, sometimes, you know, we've been, I think, agnostic as to whether or not this particular rule is a mandatory claim processing rule. I think we've said when it is a mandatory claim processing rule, so long as it's invoked by the other side, there really is no discretion. You have to enforce it. It's not jurisdictional in the sense that they could waive it, but they didn't waive it here. So, and, you know, we know what Judge Scott thought too, which was this should be dismissed now. She might have, that's what she says. She might have inartfully framed the end of her order, but it's not really confusing what she did. She's saying in the alternative, I deny it on the merits. So that way I'm going to make the Court of Appeals life a little bit easier if they disagree with me on one grounds versus the other. They've got two. So what could she have said to have made this, to have forgiven the untimeliness that wouldn't have been obvious error? I think she would have had to invoke equitable tolling that hadn't been raised before her, and that would have been an error.
I think that DPW presented in its motion to dismiss in the Superior Court. They said in the event this court denies the motion to dismiss despite the untimely filing, the court must uphold the OEA decision currently under review. I think that's what the Superior Court did. You know, I think there's a case that we've cited, it's a Siam case, and there's a footnote in that case that addressed sort of a similar issue before the OEA board, where the OEA board had not explicitly ruled as to whether a motion to dismiss was granted or not. And I think the court presented here, well, maybe what the OEA board was sort of implicitly denied it and then moved on to consider the merits of the petition, and we would represent that that's what the Superior Court did in this instance.
Can I just ask a factual question? In response to the government's motion to dismiss or DPW's motion to dismiss, there's no opposition filed, is that correct?
Are you referring to the second?
In Superior Court?
Yes, so they filed a motion to dismiss in the earlier filing and also in the second one, to the second one.
Right, to the petition for review.
Correct. Her counsel at the Superior Court did not file a response.
And
That's on the
her
docket.
counsel is not her counsel now.
Correct.
When, do we know when that changeover happened? Is that?
If you're asking when we began representing Ms. Russell, that was last fall.
So subsequent to this?
Correct.
Okay,
Yes.
so there's no argument that there's any sort of abandonment of counsel at this precise time period?
No, not there. If I could go back to the merits, we've made arguments with respect to 7 of the 12 Douglas factors. Go through them very quickly with first, and then I can walk through them more in depth. So factor 3, the department acknowledged that she had no prior disciplinary infractions within the applicable look back period, but failed to explain how its conclusion that absence of any prior infractions could be neutral rather than a mitigating circumstance. With factor 5, the department sort of repeatedly relies on this very generalized language that employees who are under the influence of controlled substances at work could hurt someone or others, but there's no evidence that Ms. Russell was under the influence at work. Factor 6, the department asserted that a sanction of termination would be consistent with how others in similarly situated employees had been treated. But the department did not introduce any evidence to support that assertion when Ms. Russell alleged at the OEA that at least one similarly situated employee had not been treated the same. Factor 8, that analysis asks about the impact, the sort of public impact on the reputation or notoriety of DPW. Their answer to that factor really did not address that question. And there's no record evidence that the public knew about this positive drug test.
But none of these arguments you would agree were presented to either the board or the Superior Court. Is that right? And I know, I mean, I know your position that there were references to errors in the Douglas factor analysis and perhaps even some slightly more specific arguments about the types of errors, but certainly not factor by factor. And so I guess I'm asking, at what level is the board and or the Superior Court required? Seems what you would be asking them to do is really reconduct the Douglas analysis anew based on a simple overarching claim that the Douglas factors were improperly analyzed.
I don't think that what she said before the OEA board was, can sort of quite be simplified to just generally, as a, general matter, the Douglas factor analysis that DPW did was insufficient. I think she did point out particular problems. She said, and this is her petition for appeal to the OEA, when again, she was a pro se litigant, she said, the agency did not properly consider the Douglas factors, including erroneously holding my length of employment as a neutral factor, not considering my personal problems as a mitigating factor, and not considering a lesser penalty. DPW clearly understood that she was challenging its analysis of the Douglas factors. And it specifically addressed factors 4 and 11 in its briefing before the OAA, that this is before the AJ. I think before the OEA board, she also said, the review of the Douglas factors was pro forma, cursory, and impersonal. They were not even aware of her proper gender. Employee was a long-term employee with a clean disciplinary record. I would say that's factor 3. And positive personnel evaluations. This would leave one to wonder if there were any mitigating factors or a combination of factors that would lead to a lesser penalty. Officials did not seriously consider any of the Douglas factors. And I think that that's sufficient to put sort of all of what we've argued before this court at issue. At the very least, I think that would put before this court factor 11 and factor 3, which we've also argued here. And I'd be happy to talk about those more in depth as well. So with respect to factor 3, that's what DPW had to consider if there were any prior corrective or adverse actions taken against her in the previous 3 years. DPW conceded that the answer to that was no. And yet they found that factor to be neutral, or in other words, according to the definition in the rationale worksheet, it had no impact on the formulation of their decision. It's not really clear how an absence of any prior corrective actions in the past 3 years could have no impact on their analysis. If a lack of disciplinary action is not mitigating under factor 3, then it's hard to imagine what could be. I want to talk about factor 10. I know I mentioned factor 11, but I think factor 3 and factor 10 kind of go a little bit hand in hand. So I'll just go to that one next, which asks about the employee's potential for rehabilitation. Specifically, if the employee acknowledged the misconduct, was evasive, or was remorseful. And Douglas further says that the employer is supposed to look at that factor in light of the employee's past action. DPW didn't consider any of that. Their only possible acknowledgement of anything that actually had to do with Ms. Russell specifically was that it was unclear whether she would be likely to engage in similar conduct in the future. They didn't analyze whether she had acknowledged the misconduct. Was she evasive, or was she remorseful? And it did not take into account that Ms. Russell had no corrective or adverse action within the past 3 years. Again, it found this factor aggravating only by relying on this very generalized language, which Douglas explicitly says you are not supposed to look at the nature of the conduct. You're supposed to look at the individual circumstances. And
Counsel, can we talk about the harmlessness question? I feel like the parties are kind of talking past each other a little bit, because the government says, and I'll ask them when they're up here, but aside from reassignment, there are no other available penalties other than termination. And you seem to be saying that the Douglas analysis informs whether to reassign as well as one of the available penalties. And I take it the government's argument is that reassignment is not a penalty, but I don't know. Again, I'll ask them. But do you have authority for the notion that you conduct the Douglas analysis to determine also whether to reassign, or whether reassign is sort of a whole separate avenue other than penalty.
I would say that those were, you know, at the very least, that the fact that there was reassignment, that's two options, right? You can terminate her or you can reassign her. And that's exactly why the Douglas factors are crucial and why it's not a harmless error to fail to rationally and conscientiously consider them. Because there was more than one option before DPW. And they didn't really consider the option of reassignment at all. So that would have been a different course to go. They didn't look at that. And that's exactly what they needed to do under Douglas. If there are no further questions, I think my time has expired. So we would ask that this court remand to the Superior Court with instructions to remand to the OEA for further proceedings.
Give you a few minutes on rebuttal.
May it please the court, Alex Famelli for the district. As some of the court's questions this morning reflect, the subjects and even type of forfeiture in this case are pretty diverse. But really at the core of our argument are two separate forfeitures, both concerning the untimely petition in Superior Court, that each serve as an independent basis, and we believe a decisive one, for this court to affirm the Office of Employee Appeals. At the outset, the petition for review was filed 6 months late in Superior Court. Now, even if Ms. Russell had a good reason for that delay, she did not brief to the Superior Court why it should equitably toll the deadline.
Okay, but that's equitable tolling, and I think that comes second in the order of operations. The first is, so Brewer didn't decide whether the timeliness requirement is a mandatory claim processing rule. We know it's not jurisdictional, but as Judge Deal said, we've been agnostic on whether it's a mandatory claim processing rule. But let's just assume that it is. That would still require the government to invoke it, the district to invoke it, but not only invoke it, but invoke it in a timely manner. And my understanding is that the district didn't move to dismiss for 1.5 years after the filing petition. So how does that constitute timely invocation of the claim processing rule?
The district moved to dismiss the petition essentially at its first opportunity, which is to say when the court set the case for briefings. I would also note, as I believe that a judge of this panel had noted when my friend was up here, that even this alleged forfeiture on the part of the district was not something that was raised on the part of Ms. Russell.
Okay,
Essentially,
but can we look at the court's order, right?
Sure.
The court's order denying the petition for review, not dismissing, right? And the court says, look, I know I have a motion to dismiss before me as well as an opposition to the petition for review. I know that there's no response to it, right? Acknowledges these are the only pleadings that I have in front of me in the first paragraph. And then the court says, I'm denying the petition, says that on the bottom of page 1. Says that at the end of the order twice, based on the foregoing, the petition is denied, ordered that the decision is denied, the petition for review of the agency decision is denied, right? The court acknowledges that the petition for review is untimely, but also knows the procedural history, knows that this pro se individual filed the wrong form and that tied things up for a while. Why shouldn't we at least remand to find out why the court acted the way that it is? I think we have to trust the court used the words it wanted to use to deny the petition, to see whether it actually was dismissing in the alternative to the denial. If not, just assume, look, it's clear that the court didn't dismiss, it did deny, the government didn't cross appeal, and so we've got a denial on our hands.
We don't see a reason to remand, and there are essentially two reasons why. First of all, the way to evaluate this claim is not to hang on to creedal language like dismiss or deny. That difference has no legal significance. And one example of that is that.
It has no legal significance?
Well, as relevant here, I
I
should
think
say.
it has quite a bit of legal significance, right? So, sorry, continue as to why we shouldn't remand.
Sure. The reason it
find
has
out
no
what the court
legal
is doing.
significance is the context of the opinion. And so what I can point to as an example of this is really case after case in the DC Circuit, for example. The circuit is denying petitions for review. That's the language they're using, even though what they're actually doing
Right,
is.
but this is different, right? Because here it is teed up for the trial court as you have choice A and you have choice B. Choice A is dismiss, choice B is to deny. And it's very clear what the options are on the menu, right? And the court chooses to deny, right? Acknowledges choice A, chooses choice B. So it matters not a whit to me that other courts use deny petitions in some circumstances, perhaps even our own, right? In this case, you have the trial court given two options. And it knows that it has a pro se individual, and it knows what this court has said about helping pro se individuals. And all the evidence that the court has is that this individual is trying to timely appeal to seek review. And so acknowledges the timeliness issue and moves on.
The problem is what the court says doesn't line up with that. It doesn't acknowledge.
What part of the order doesn't line up with that?
Well, it says the petition was nearly 6 months overdue and should
Yes,
be dismissed.
acknowledges untimeliness. Where does it say this should be dismissed as the government requests?
When it turns.
It's at page 4 of the order. At that point, the petition was nearly 6 months overdue and should be
Sure.
dismissed.
Should be.
Yeah.
But it doesn't say it is.
It seems to me to be a characterization of the district's argument. Because the rest of the paragraph above it is a characterization of respondent's argument.
What the court says before it proceeds to those alternative arguments or those alternative bases is, however, even assuming the petition was timely, it doesn't say assuming without deciding. It also doesn't do what this court referenced in Seam, brought up by my friend a few moments ago, where an AJ, or excuse me, in this case, a Superior Court judge acknowledges an absence, or sorry, determines that there is jurisdiction, acknowledges that jurisdiction, and then continues to rule on the merits. I would say that that's not in appearance or in substance what the Superior Court
It just
is
strikes
doing
me that you're asking us to ignore the plain language of an order that ends. Accordingly, it is this 22nd day of June 2023 hereby ordered that Francois Russell's petition for agency decision, petition for review of the agency decision is denied. That's all it says.
Sure, but even from that language, I mean, there are.
Not from that language, because there are two different choices, right? The court has acknowledged that it could dismiss and it is, or at least has a motion to dismiss before it, and has acknowledged that there's also an opposition to the petition for review. So in that circumstance, I mean, at the very least, it seems like we need to send it back to the trial court to say, did you not mean deny when you said deny? But I'm not sure that we shouldn't take the court for its word when it said denied, right? Courts know how to write orders. This court wrote one.
If the court were sua sponte, granting equitable tolling, I would expect that the opinion would have some language suggesting that it had.
Maybe it was in its head. We don't know. All we know is that the court said the petition for review is denied.
I would also suggest that simply the fact that the court goes on to consider these alternate bases for relief doesn't suggest that it's somehow ruling against the district as to that first point. I mean, it's essentially good practice on the part of a trial judge to.
Can I just interject? And, we're kind of having this debate about what exactly it is that the trial court did. And I wonder why we care. Because one argument that I understood you to be making, correct me if I'm wrong, is the trial court could not have done anything but dismiss. Isn't that, it had to dismiss. So whether it did or not, we should remand and direct it to dismiss. Is that part of your argument?
I certainly wouldn't object to that characterization of our argument, yeah.
I mean, you raised the timeliness objection. It is under Rule 1. That is, you guys don't really fight out the mandatory claim processing rule analysis, so I don't know what to do about that. But generally speaking, you've invoked a rule-based timeline that says you must file within 30 days. That doesn't happen. There's no argument for why that should be forgiven here, raised by the petitioner who was then counseled. How could the trial court have done anything but dismiss this as untimely? And if that's right, why wouldn't we just affirm on, the alternative? Now, I get it's not exactly an affirmance because, the decretal language is slightly different. But as you said, these are not magic words. You could find the same cases from this court sometimes that use the word vacate and remand and sometimes use the word reverse and remand. And there's a whole article by Judge John O. Newman that I recommend to you that talks about decretal language. And it's a great read, but part of its bottom line is everybody's really sloppy about this stuff. So assuming she was sloppy about it, why should we care about that? So what? So she said deny, should have said dismissed, but she must have said dismissed because that's the only option she had available on the table, right?
Yes, I mean, my view is that that is the only way to read not only what the Superior Court said, but also the options before the court and how the court could have possibly been interpreted to rule on that first question.
Why is that question even teed up? Right? I mean, if the court sua sponte decided that there were equitable reasons to not, I mean, the court knew all the facts, right? It's not a situation where someone is saying, oh, I was ill, much later, right? I missed the deadline because I was in the hospital or something like that. The court knew that she had filed this wrong form in a timely manner. And, if the court is implicitly relying on that, not to rule on it, maybe that's right, maybe that's wrong. I don't know that we've squarely addressed that scenario, but it doesn't even seem teed up for us. We don't know what the court did. I mean, if we don't take the court at its word that it was denying, which, ambiguity about decretal language aside, I think in this factual scenario, it's pretty clear that the court made a choice.
To make an extremely obvious point that the court already knows as to why the question isn't teed up. The first reason it's not teed up is that it wasn't raised by Ms. Russell. She didn't respond to the motion to dismiss. She didn't have any sort of affirmative briefing.
But if the court decided it implicitly, but we don't know because we're saying denied doesn't actually mean denied. Maybe it means dismissed. What do we do then?
Well, in a situation in which this court, I mean, I just don't think the court can read sort of a move on the part of the lower court that really is in no way telegraphed by the opinion itself. There is a footnote suggesting that the Superior Court judge was aware of some degree of this this turbulence, this attempt to file in the wrong forum. But the facts were not put in front, the relevant facts were not put in front of the Superior Court judge because they were not raised by the appellant in either instance, either in her own brief or in response to a dispositive motion to dismiss, which was largely, or I should say the motion to dismiss portion of the opposition was grounded entirely in that point. If it's all right with the court, I'll move on briefly to the two other points that we raise here. There are two aspects to our handling of the Douglas analysis. First is another argument about forfeiture, because Ms. Russell's brief in this court is the first time that she ever argued about specific omissions, specific flaws, specific claims of error in the Douglas rationale worksheet. Before the AJ, all she discussed was the mayor's order and the resulting amendments to the suitability regulations. And before the Superior Court, the same thing. Now, we also make a harmlessness argument, which I think is significant given that Ms. Russell is a safety-sensitive employee, a particular type of covered employee for whom the options here, as we've gone through throughout our briefing, are only reassignment or termination. The fact that the agency could have used its discretion.
Can I ask a factual question about that? Why is that? What is it about Miss Russell's job that made her safety sensitive? Was she like driving a vehicle from the district? Could she not have been put on a foot beat that would have eliminated that?
Driving a
safety
vehicle
concern?
was part of her responsibilities.
Uh-huh.
Under the suitability regulations, under section 400 of the regulations, if you fail a random drug test,
Uh-huh.
that is, part of your list of responsibilities as a safety sensitive covered officer. That is a basis for termination, and any alternative to termination, which in this case would be reassignment, is squarely at the discretion of
But
the
it's at
employing
the
agency.
discretion, but I mean, everything's at the discretion, right? I mean, if there were a range of penalties, and I know you're saying there weren't here, but let's say she wasn't a safety sensitive employee, there would be a range of penalties. And those would still be discretionary, right? So they would still be informed by the Douglas analysis. So I'm not sure the fact that reassignment is discretionary answers the question of whether the Douglas factors speak to it or not. I mean, your argument would have to be, and it would have to be correct, that the Douglas factors go solely to penalty in its strictest sense, meaning termination versus suspension versus docked pay or whatever the range of penalties are. And reassignment is a completely different animal from penalty. Is that your position, and what's the support for that?
That is our position, and I would say that the main area of support is that these penalties are squarely within chapter 16 of the district personnel manual and the associated regulations. And as a great example of that, there is this table of illustrative actions, which lists termination and also lesser penalties as options that an administrative agency can pursue when reprimanding an employee. There's counseling on the list, reprimand, suspension, reassignment is nowhere on that list, because it is referenced in the suitability regulations as an alternative to termination. So it is treated conceptually differently.
And so you're saying what normally happens is not sort of Douglas analysis, okay, this was, 5 were mitigating, 5 were, or, 3 were aggravating, 2 were neutral. So based on that, we choose reassignment? That's not what happens? Is that what you're saying?
Right. Our view is that reassignment is not some sort of middle option for an employee who maybe satisfies some of the Douglas factors, but not others. It has to be discretionary. It has to be based on the circumstances available to the employer, just as if they were hiring somebody from scratch. This is essentially an action that follows termination and is entitled to an even greater degree of deference than what an employing agency normally gets under the Douglas analysis.
And so, I mean, you're saying that it's just an odd quirk of the system that for a safety sensitive employee, I mean, you use the word superfluous in your briefing, that the Douglas factors are just, I mean, they're just gone through for no purpose then at this point? I mean, everyone went through them. No one has recognized over all these many years since 1981 that the Douglas factors are pointless in the case of safety sensitive employees?
The answer doesn't matter for this case, but our position is that, yes, as far as a positive test result that's contemplated under the suitability regulations is concerned, if that makes you subject under the regulations to termination or reassignment at the discretion of the agency, that's what it means. And you can sort of see this tension. It's a good thing that the agency.
Except now, right, isn't there a lesser penalty? Isn't the five-day suspension available? So the Douglas factors do work in this scenario, no?
Under the new regulations, suspension is recommended for a first offense of a positive cannabis test for a safety sensitive employee. Termination is recommended for a second offense. That is the newer regime.
So the government's theory is for all these decades, the Douglas factors were defunct, but they were revived with the new 5-day suspension. Suddenly they are operable in this scenario for safety sensitive employees.
Well, it depends. I mean, sort of under the suitability
I mean,
regulations.
your only argument that the Douglas factors, right, because the reassignment, you say, is discretionary. So,
Yes.
I mean, the discretion has to be bounded by something, right? You would agree that it can't be completely arbitrary, I'm gonna exercise my discretion to flip a coin to decide whether or not I'm going to reassign this person to a position that I have.
I would analogize that, I suppose, to areas of Title VII law where there were certain sort of outer bounds, sort of, rules against discrimination and.
I mean, do you
that
have
sort-
any reason why we wouldn't put the Douglas factors in as sort of a precursor to, okay, use the Douglas factors to figure out if this person, like assuming you have a position to reassign them to, whether or not this is the person that you're gonna use that chit on.
I don't object sort of, I don't object to the use of the Douglas factors. And I think that it was a good thing that the Department of Public Works used them. I do think that their reliance on them reflects attention. You saw that in a number of these factors, they kept going back to, well,
But the government never said, oh, don't. I mean, DPW never said that you have no business applying the Douglas factors in this case.
in the rationale worksheet, DPW never made any such suggestion. But it was the view of the district, was the view of DPW in every tribunal from that point forward, that suitability regulations are chapter 4, Douglas is chapter 16, and it was our view preserved from the earliest possible moment that these are essentially two different rubrics.
And you would agree that Ms. Russell could challenge the discretionary decision not to reassign her, perhaps not under or pursuant to a Douglas analysis, but standing on its own, except that she never asked for a reassignment? I mean, is that your?
I think under the law, there is probably some basis for that kind of challenge. She never asked for reassignment when DPW was considering her case. She never asked for it at the hearing or in any communication with the agency. And beyond that, she never raises it at the OEA board, never raises it in the Superior Court.
I mean, is there any, what's the authority that the employee has to ask for their reassignment as opposed to it simply being a part of the decision-making process of the agency?
Well,
Right, isn't it enough that she says, please don't fire me?
she says, please don't fire me, essentially because I have a retroactively valid medical marijuana card. That's what she says in front of the Department of Public Works hearing officer. That's really the entirety of her argument there.
Right, but she doesn't want to be fired.
Well, sure, but we have no sense as to whether, I mean, there's so much speculation required as to the reassignment question. We don't know what positions are available.
She wouldn't know what positions are available.
That's fair. But if what she's recommending is that she be excused from the discipline because of this medical marijuana card, what she's asking for is to be retained to her initial position. She says nothing at all about reassignment or sort of alternatives to her principal case. Unless there are further questions, I'm happy to rest there and urge the court to affirm.
Thank you, Mr. Femeli.
Thank you.
I'd like to make two points on rebuttal. The first is I know we've already discussed it at length, but just to go back briefly to the timeliness issue. I don't think it can be possibly correct to say that the Superior Court thought that it didn't have any option other than to dismiss. DPW gave it another option other than to dismiss. It said, if the court decides not to dismiss, it should deny on the merits. We think that that's clear from the court's decision.
I mean,
That's
why,
what it-
well, I have a more targeted question, but my reaction to that is, well, if you get it wrong, we should still win. Not, you could correctly decide against us on the dismissal order. Why isn't the better way of reading DPW's alternatives say, you should dismiss? It's really what you need to do here. If you get that wrong and you disagree with us, which, we might appeal, well, you should still rule in our favor on the merits. What's odd about that?
I would read it as saying, sure, we want you to dismiss. If you don't, we want you to deny it on the merits. And I think more than what DPW asked for is what the court did. And we think it's clear that the court's decision, it was clear that it was denying it, not dismissing it.
I mean, so this is my more targeted question. I really don't think that's clear. I think I think the trial court was sloppy in the decretal language, but every bit of her analysis suggests what she wanted to say. What she should have said is the petition is dismissed, and in the alternative, I would deny it on the merits. But we could clear that up, presumably within a week or so, and remand the record to the trial court for clarification and say, option A, did you mean to dismiss this and in the alternative deny it on the merits? Or option B, did you mean to reject the motion to dismiss as untimely and only decide it on the merits? And if she comes back with option A, what's left of your argument? Is this case over?
Option A would be that.
That I meant to dismiss it as untimely and in the alternative deny it on the merits. There's no attack on sort of, so far as I can remember from your briefs. I don't think you levy any attack against that if that had been what she said. And so if she clarifies that on remand, what is left of this case?
Yeah, we think that, as a general matter, their court should consider the merits. We think she undeniably considered it on the merits. And so we would ask this court to do that as well. To the second point, which is, whether reassignment was sort of another penalty option such that it was relevant under the Douglas factors, we think it absolutely was. So the relevant regulations are 428.1, that's DPW cited that in its paperwork to Ms. Russell. That says there shall be cause to separate an employee from a covered position as described in section 435.9. So 435.9 says if an employee is deemed unsuitable, the employee may be terminated, or instead of terminating the employee, the personnel authority may reassign the employee to a position for which he or she is qualified or suitable. So I think that's very clear that those were two different penalty options. We can terminate you or we can reassign you. The other section that they cite is 439.3, which is sort of the procedural process if you do decide to terminate someone. So, I don't think that's directly relevant here, but it does have language that I think really underscores that point, which is if the program administrator determines that an employee is unsuitable to continue serving in a covered position, comma, and that he or she should be separated from employment, and then sort of the process is described. So I think that makes clear that determining whether an employee should continue in a covered position and determining whether an employee should be terminated, those are two separate inquiries. Termination does not necessarily flow from an unsuitability determination. And so for those reasons, including the ones that we've raised in our brief, we would ask you to remand to the OEA for further proceedings. Thank you.
Thank you, Ms. Hampshire. Thank you again, Mr. Femelli. The case will be submitted and we stand adjourned.
Oh.